Welcome back. Let's tell you about widespread criticism of proposals in the Electoral Amendment Bill. The amendments follow a ruling by the Constitutional Court which require changes to the law to allow for independents to participate in elections in a better way. For more on this, we're joined by Electoral Institute for Sustainable Democracy in Africa's Governance Program Head, Grant Masterson. That was quite a bit to get out. Grant, welcome to the program. Tell us first why this bill is so problematic, these amendments to date.
Hi, Tembekile. So the amendment bill, firstly, we should note, is not yet enacted. So we are still talking about something that may still see some changes. But if the bill as it is currently being discussed goes ahead, there are several areas which many people are quite concerned about, starting with issues of proportionality. South Africa has a constitutional requirement that the electoral legislation provides for a proportional system, not necessarily a PR system, which is a specific type of electoral system, PR being proportional representation, but that the results should be proportional. There are several electoral systems in the world that produce quite different results to the popular vote, the United States of America being a very obvious case in point, and our Constitution requires that. Now, the amendment bill that we're looking at here has the potential to see some real distortions in that proportionality. So that, for starters, is one of the big problems that we're looking at.
Would I be right then to say the contention is that the bill, in its current state, is setting up independent candidates for failure?
Yeah, absolutely. That's another big problem here. This amendment bill came about because the Constitutional Court actually required that Parliament pass legislation to allow independents to contest national elections. So we're sitting in a position now where the bill as such is allowing for that contest, but it's not creating a fair contest. Now, the issues of unfairness occur in several ways. Firstly, there is a disparity between the requirement of signatures for a political party and for an independent candidate. So independent candidates may in actual fact have to get more signatures to nominate them onto the ballot paper, which is one of the requirements before you can appear on the ballot paper, than a political party. The other, of course, is that there will also be the requirement for a deposit for an independent candidate, although we don't know what amount or quantum that will be at this stage. But these are issues of concern. And the complex and more technical answer about the fairness issue as well is that because independent candidates are contesting and are allowed to contest in multiple provinces, the benefits to the largest political parties of having large numbers of independent candidates on the ballot paper mean that actually you might see a bigger distortion in favor of large political parties, even at the cost of smaller parties and the independent candidates themselves.
But regardless of whatever the amendments finally that will be signed into law, Grant, are, can the playing field ever be entirely level when you consider that these are independents, for instance, who'd be going against, I'll use the top three examples, an ANC that's had a almost 30-year head start in terms of democratic elections and contestation there, a DA that's had enough time to cement itself as the official opposition, an EFF that's carved out what some would say is a niche among the electorate, and all of them have already people who are willing to pour funds into their campaign. So can it ever truly be said that independents and political parties are given an even playing field?
On the even playing field, I think we would need to see different amendments made to the electoral bill as such. So in its current formation, no, I don't believe that we're going to be able to achieve fairness between independents and the parties that you mentioned, or even any of the other political parties. However, what we need to remind ourselves here is that we already have a system which allows for perfectly fair contestation between independent candidates and political parties at the local government level. And one of the possible options that was considered and then discarded was that we simply export that system to the national and provincial level. Now, that was discarded quite early on as an idea, as a potential solution to this problem. But we have to remind ourselves that in South Africa, we know how to hold an election where independents and political parties contest side by side. And when you look at the results, the popularity of independent candidates appears to be growing. So the number of independent candidates elected in the last local government elections was the highest that it's ever been. So it is possible to have a fair playing field. However, the current Electoral Amendment Bill does not seem to provide for such a playing field.
So do you then think the lawmakers who are now in charge of this process, is it that they don't understand the full nuances of the assignment, shall we say, given to them by the Constitutional Court, especially with the deadline looming in December? Or are they crafting these amendments, these changes, with their own advantage in mind?
Yeah, I was reading an article by Carol Payton today who was saying that turkeys don't vote for Christmas, and so that's certainly her opinion. I don't know. I don't believe that the lawmakers as such do not understand the issues with the bill, because there's been not one but two public hearings, public calls for submissions, which have been well presented. The issues have been discussed in the committee of the Department of Home Affairs, and the minutes show that they did discuss the issues, and then they still came to the conclusion that the electoral amendment should move ahead as is. So I don't believe that it's not that they don't understand it. I can't speak to personal motivations of the people involved, but I do think that we can cast an eye on their motivations and look at them very carefully.
I reference the extension deadline, that's December 10th of this year. The elections, national elections, are now less than 2 years away, 2024. Will we meet that deadline? And if we don't, what's the cost then to electoral reform in South Africa?
Look, this is probably the most serious concern that I have, and that is that we are running out of time. In fact, as we sit right now, the IEC ought to, under ordinary circumstances, already be preparing for the 2024 elections. Now, preparing for those elections requires that you understand the legal framework within which those elections are going to be held, and we don't have that yet. Legal processes take time. From the promulgation of the bill to the signing into law on the president's desk can still take some time. And this is not even including the possibility of challenges to the constitutionality of the bill itself. And so this is a very, very serious concern, because we may be going into 2024 unclear on what the legal framework for the country's electoral system actually is. If the Constitutional Court does consider a challenge to the Electoral Amendment Bill, then we begin and initiate a new constitutional process. The courts also take their time, and even if you try and expedite it on an urgent basis, the IEC is losing precious time even as we speak. Even right now, we should be comfortable about the extent to which the legal framework is solid and the IEC can prepare. And we simply don't have that clarity right now.
So given the urgency of the matter then, Grant, I know civil society at this point has opted to, shall we say, mount a public pressure campaign. There's been a letter sent to Parliament asking for these changes to be re-looked. Is it too soon to perhaps go the legal route to challenge the bill in its current form? Would that be premature?
Yes, you can't challenge a bill. We have legal precedent for that, and civil society organizations have taken legal advice on that matter, and we're fairly confident that you cannot challenge a bill until it is signed into law, and so we cannot review that until such time as we know the exact nature. And that's why I did emphasize at the beginning of this discussion that there may still be changes. We hope that there are changes that can improve what we see in the bill right now, because we need a framework that creates a fair playing field and is constitutional, because the 2024 elections are expected to be very, very competitive elections. There is the concern about, will the ANC retain its majority at the 50% plus one vote mark, as well as where do the other parties perform. And so, we really are approaching 2024 kind of limping towards 2024 when we shouldn't be doing so. We should be striding forward confidently, knowing that we have a legal system, a constitutional framework that is going to guarantee the freedom and the fairness of the vote.
Grant Masterson from the Electoral Institute for Sustainable Democracy in Africa. Thank you so much. He's the governance program head there.